question on the floor here.
Marcus Lynch from WebSense. Just wondering, does the Schleswig-Holstein opinion cast doubt on the safe harbour data protection arrangements between the EU and US?
It does, funnily enough. I haven't read the English version yet. I've just read a summary of it. It's still in German because it's off the press, but I understand from the summary of it I read that they have a go at safe harbour. And a lot of, we say, data privacy regulators are having a go and losing confidence in safe harbour. I believe that the tone of the opinion is that safe harbour ticks a box, a very specific box, and it deals with a very specific issue of export of a type of data to a safe harbour company in the US, but it doesn't mean that the exporting company has complied with data protection law. They make the point that, you know, the export of data protection from interjurisdiction is one of, you know, many facets of data protection law. So I think that's the point that they push home, is that you can have a safe harbour arrangement, but you're not there on security. You know, you still have a security issue and you still have other data protection obligations. So I think they speak somewhat negatively about safe harbour, but interestingly that opinion does speak rather highly about a very new model for exporting data internationally called binding corporate rules. A somewhat expensive model and used normally by very large global corporations, whereby they adopt a global data privacy constitution, which in turn facilitates the international movement of data, and the regulator there, he gave the nod to that, I understand.
Just to mention as well, maybe on safe harbour, that interestingly, as you mentioned, it's one of the frequently produced differentiators, I suppose, by companies, particularly US-based companies, obviously, to state safe harbour compliance as one of their selling points, one of their differentiators. And there's been some recent challenge to the whole quality, I suppose, of safe harbour compliance because of the nature of being self-regulated, because it's not as controlled, I suppose, as data protection compliance would be in European countries, and because it's a company-to-company setup rather than a broad-based countrywide. So there's without casting aspersions on the goodwill, I suppose, of organisations that claim to subscribe to it, at the same time there are challenges coming in as to the validity of the safe harbour claims. And the encouragement would always be for organisations, particularly for data controllers, even where they see safe harbour compliance as one of the profile elements of a destination, that they would still be encouraged to pursue the adequacy considerations and to do an extra piece of investigation, I suppose, or of due diligence before sending their data to those destinations. It's not enough in and of itself.